We should be streaming shortly. Okay, Mr. Court Reporter, can we please go on the record now?
You're on the record, Your Honor.
Thank you. This is a pre-hearing conference in case number 9490 in the matter of the application of the Potomac Edison Company for adjustments to its retail rates for the distribution of electric energy. My name is Kristen Lawrence. I'm the public utility law judge assigned to this case. Counsel, please identify yourself and your client for the record, starting with Potomac Edison.
Good afternoon, Your Honor. Max Curran on behalf of the Potomac Edison Company. I'd also like to enter the appearance of my colleague, Christopher Gunderson from Venable, as well as Jeffrey Trout, Senior Corporate Counsel for Potomac Edison, along with his colleague, Teresa Harold, also counsel for the Potomac Edison Company. Thank you.
And OPC? Mr. Alexander? You're still muted. Mr. O'Loughlin, are you there?
Here we go. Sorry, Your Honor. I just the computer thing. Anyway, I'm Gary L. Alexander on behalf of the Maryland Office of People's Counsel, and I'd also like to re-enter the appearances of William Fields, Joseph Cleaver, and Patrick O'Loughlin on behalf of the Maryland Office of People's Counsel.
And staff?
Good afternoon, Your Honor. Lloyd Spivak for the Commission staff. I would also like to enter the appearances of Michael Dean and Leslie Romide.
Okay. Do we have any preliminary matters other than the procedural schedule that we need to deal with?
None, Your Honor.
Okay.
No, Your Honor.
I did receive your email about a little over an hour ago with a proposed schedule. I pulled up the scheduling order in the phase 1 proceeding, which was a full rate case, and noted that in that case, staff and OPC had to file their direct testimony less than 3 months after the filing of the case. So I'm wondering, first from OPC, what about this depreciation proceeding? Phase 2 requires almost 8 months to file direct testimony. Mr. Alexander?
Your Honor, I'm going to defer at this point to staff and I guess Mr. Curran too, please, and then I'll chime in if necessary, if I may do so.
Good afternoon, Your Honor. Basically, the delay was at the request of staff, and it had to do with staff resources, in particular the divisions that will be addressing this, especially the accounting division, was looking at their workload over the next several coming months, and they specifically requested that we seek to postpone the beginning of the case until that spring. They're down some people, and they have the major PEPCO multi-year rate plan case and a number of other cases ongoing, and they didn't think they had the staff. They would have staff availability until then.
This is a depreciation matter, correct, Mr. Spivak?
That's correct.
Is staff hiring an outside expert?
I don't believe so. It will probably be the accounting division that provides the staff's witness. I suppose there is an off chance of a consultant, but that's unlikely.
You said accounting witness, so one?
At least one. I think there will also be an engineering witness.
So 2 witnesses from staff?
Correct, Your Honor.
Okay, so I know the company has 2 witnesses. Staff, you just told me 2 witnesses. I'll ask Mr. Alexander the same question, but does anyone understand why in a case that might have 5 witnesses, we need 4 attorneys for the applicant and we need 8 months to file direct testimony? It's excessive compared to a regular rate case that has multiple issues. Mr. Alexander, you represent the residential ratepayers, including PE's ratepayers, correct?
Correct, Your Honor.
Isn't an issue in this case when the rates take effect?
Yes, Your Honor.
If there's a possibility that rates might go into effect that would be lower than the current rates, wouldn't it be beneficial for that to happen sooner rather than later? But I'm talking to Mr. Alexander right now. I'll hear from you next. Mr. Alexander, you're muted.
Here we go. Okay. Yes, Your Honor. The answer is yes to your question. I'd like to address the other question you answered. One, we will have, as of now, 1 depreciation expert. And the reason why we have 4 attorneys is just for coverage because we're shorthanded. Bill Fields is the deputy.
Mr. Alexander?
Yes.
That comment was really directed to the applicant.
Yes, okay.
Who the ratepayers have to pay for their counsel.
It's
especially
true,
their
Your
outside
Honor.
counsel.
Yes, Your Honor, it's true.
Okay, so 1 depreciation expert for OPC, correct?
Correct, Your Honor.
Have you already retained that expert?
Yes, Your Honor, and we have already issued our first set of data requests.
Okay.
Just a few days ago.
Okay, thank you. Okay, Mr. Spivak, you wanted to say something. You were muted, Mr. Spivak.
My apology, Your Honor. The rates that come into effect at the end of this case aren't actually retail rates. They're the depreciation rates, which are an input for the retail rates. And what is required to happen based on the order from the phase 1 of this case is that Potomac Edison is required to file a new rate case within a 5-year time frame, or from the end of the original case. I believe it's by 2023, and these we recognize that has to happen, and that was played into our time schedule on this. But the time schedule was designed to make sure that we can accommodate giving Potomac Edison adequate time to prepare its rate case when this case is done, and still be able to file the retail rate case in a timely manner within the requirements of the Commission's previous order.
Wouldn't not stretching this proceeding out help them in what you just said?
It might make it possible for them to file sooner, but it wouldn't. But stretching the schedule out as we have still allows them sufficient time, more than sufficient time, to do what's required.
Okay, but you haven't provided me any additional reason for the 8 months, though, correct? Other than staff's.
Other than that, our witnesses do not think they will really be available until that time.
Your Honor, may I speak?
Oh, yeah, let me finish with Mr. Spivak.
Absolutely.
I didn't understand what you were saying in the beginning, though. Are you saying that the depreciation rates that'll come out of this proceeding would not have any effect? There's no time element to the effect of those rates?
The time element to the effect of those rates depends on the timing of when Potomac Edison actually files its next rate case.
Really?
the rate case that's required. They don't go into effect at the end of this proceeding. The depreciation rates are simply inputs.
That's staff's position.
That's staff's understanding of how this will work. If the company has something different, they're welcome to say so. But that is staff's understanding, yes.
Isn't there something about a regulatory asset?
I would defer to the company to respond to that.
Okay. Mr. Alexander, were you wanting to be heard?
Yes, Your Honor. On a particular thing about the attorneys, we until your question, Your Honor, I'm sorry I didn't give it as much thought as I should have, but we don't think that this requires 3 outside counsel and 1 senior in-house attorney, even though we've listed 4. I'm going to do the case with Mr. O'Laughlin, who has only been with us for a year or 2 and never done depreciation, to try to bring him into it, because I'm the only one who does depreciation. And I don't think you need 3 lawyers from Venable and the senior counsel for Potomac Edison to handle a depreciation case.
Okay. Well, I'm not, you can address that. I guess that issue will really come up in the next rate case. I just wondered if there was some reason, some complexity I'm missing for why we needed all these outside counsel for Potomac Edison. I'm not sure I understand your position, Mr. Spivak. From my review, I think there is a timing issue here. And I could be wrong, but I think there might be. Mr. Alexander didn't address that, so maybe he doesn't know for sure either. But this scheduling order, I don't think the commission asked for a depreciation study to be filed only for staff to disregard it for 9 months until it thinks it has time to look at it. It's excessive, and I can't do that. Not when this regular rate case, staff provided direct testimony in less than 3 months. So if staff needs to hire an outside expert, whatever it needs to do, but 8 months before it plans to look at this case is not acceptable. So looking at something more like 4.5 months from the date it was filed would take us to the end of January for direct testimony. Let's say January 29 is a Friday. Then rebuttal would be due March 2nd is a Tuesday, with surrebuttal due on Friday, April 2nd. And the evidentiary hearing could be held in mid-April. Anybody have any conflicts in mid to late April?
Pulling up my calendar now, Your Honor. If you give me one moment.
Your Honor, I think you said so many screens. Did you say April 2nd?
I did. For surrebuttal?
Yeah. Well, I usually it's near the end of Passover. I usually only take the first 2 days off, so
you can always file your testimony sooner than the deadline. Not a problem.
Your Honor, I already have 10 cases that are going through this, and the one thing I'd like to say, Your Honor, is that none of the counsel here can tell us we have not yet received or had a pre-hear scheduling conference for the PEPCO MRP, and based on my experience now with the BGE MRP, that will be work. But right now they haven't. So the dates that you said, and can I just have the last one again? I've got April 2nd. And what was the next one, please?
We're looking at an evidentiary hearing in mid-April.
That will be, are we talking something like the 6th, 7th?
No, more like the 12th, 13th, or even 19th, 20th.
12, 13 for OPC, Your Honor, is fine, as are the 19th and the 20th. I don't see anything on my calendar. Thank you, Your Honor. I'm going to mute again.
Your Honor, I just did have an opportunity to check my schedule, and those dates are fine for an evidentiary hearing in mid-April.
Thank you. Staff?
We do not at this point have any conflicts with those schedules.
You're anticipating a conflict with?
I am, Your Honor, because I expect that that will be the timing for the PEPCO multi-year rate plan. I don't know yet when those hearings will be, but I would not be surprised if they are in that vicinity. And maybe they may be a little sooner. I'm not sure. We haven't worked out that schedule yet.
Your Honor, may I speak for just quickly? I haven't checked the dates you just said with my expert. I don't expect there to be a problem because like not many people are traveling at this moment, at least. So we can run with those dates. And if there is some sort of conflict with my expert, I'll get to everybody right away. But right now, the dates you said are fine, and I don't think we'll have a problem with our expert.
Okay, thank you. And then after those hearings, the same amount of time, well, no. The other thing I noticed was you proposed to have over a month between the evidentiary hearing and the initial briefs. That's a little long. The 2 weeks between the initial brief and the reply brief is fine. Is there a reason you, other than the things we've already discussed, based on this case, is there a reason that this case after the evidentiary hearing would require well over a month to prepare an initial brief on one issue?
Yeah, Your Honor, that was my fault because under the initial proposed schedule, Labor Day was September 6th. So I thought we would give folks a few extra days after Labor Day, but there's no reason why we could not adhere to a 30-day briefing schedule.
I don't even know why you would need 30 days. It's a single issue proceeding. So usually the initial briefs come in 2 weeks after a full rate case. So 30 days is again, I think, even more than you need.
Have Your Honor relate the briefs earlier. That's not going to be a problem.
Okay.
Your Honor,
yes,
if I may
Mr.
speak
Alexander.
again, I thought 30 days was for a rate case, but in any event, we're still an attorney short, Your Honor, and there's going to be some changes in the office, which I can't discuss, and we would appreciate 30 days, maybe a tad less, but also I am supervising Mr. Laughlin, and it may take him a little longer, like it did me 14 years ago, to start to get arms around depreciation. And so we would want closer to 30 days if it doesn't displease Your Honor too much. Thank you. I'll mute.
Okay. Other than that, putting in the timeframes you have for discovery and the number of days for responses and objections is fine. I'll just adjust it to the dates we've now discussed. Okay, does anyone have anything else at this time?
Your Honor, apology. Could you run through those dates just one more time? I know.
Sure. I mean, I will be issuing an order, but it would be direct due January 29, rebuttal due March 2, surrebuttal due April 2, with the evidentiary hearing tentatively April 12 and 13. Oh, the other thing is, I think you said 3 days. I can't imagine why we'd need 3 days for 5 witnesses unless someone has some information I don't.
No, Your Honor. I think 2 days would be sufficient.
Okay, so we'll schedule in 2 days. Makes it a little more easier to find time in the schedule. Okay, does anyone have anything else? I know no one's happy with this, but
Your Honor, this is Jeff Trout, and I apologize if they start banging in the background and mute as quickly as I can, but construction is going on in my house as we speak. I can briefly address the concern you raised earlier about the number of applicants, counsel, or not, depending on whether you want to hear from the company on that subject.
it's not really my issue. I suspect staff might be, and maybe OPC even might be raising it when the cost of that is sought to be recovered. I was just kind of noticing it now since it is just the single issue. Mr.
Why don't I
Spivak?
Actually, given the earlier time frame of the case, that might not even show up in the test year.
Okay.
Your Honor,
I just want to correct the misimpression reflected in your initial remarks. There aren't 3 outside counsel and 1.
No, I have 2. I have 2 inside and 2 outside, right?
Right. So
2.
Mr. Curran and Mr. Gunderson switch off, and Ms. Harold and I switch off. So we'd only have at most 2 attorneys working at any one time, and in many situations, it would just be either the company's counsel or the company's outside counsel. So I think any suggestion that we are overstaffing this is misplaced. But Your Honor, get the outside of the case with a misimpression as to what's being done or why.
Okay.
Okay. Your Honor, can I just have one last question? Because I missed when the initial post-hearing brief will be due.
Well, it'll depend on the evidentiary hearing, but if the evidentiary hearing is April 12th and 13th, like we are thinking, then giving you the 30 days you want would maybe May 11th or so.
Oh, I don't know if I'm on or not.
You are now, yep.
Okay. Yes, Your Honor, that would be very helpful, and I do appreciate the courtesy and your patience. Thank you.
Okay. Does anybody have anything else? Seeing nothing and no one else, this meeting is adjourned. Thank you. We're off the record.
Thank you, Your Honor.
Thank you.
Have a great weekend, everybody.
Thank you. You too.